Of course, today we saw a closed-door session, which lasted for several minutes. Now, the Senate came out of that closed-door section and asked that state and local government to immediately comply with the Supreme Court judgment, particularly relating to local government accounts and the funds given directly to them. The Senate also resolved to take immediate steps to alter sections of the Constitution to give full autonomy to local government administration in the country. The resolutions was announced by the Deputy Senate President, Senator Jibrin Barau. Lawmakers upon the reconvening from a closed-door session where the chamber debated attempts by some state governments to circumvent the ruling of the Supreme Court. I have the man who moved the motion on the floor today, Senator Tony Nwoye. He's live with me here in the studio. But before we get into that, there is another very interesting scenario playing out. Is the fact that the Supreme Court has scheduled on October 22 to hear a suit filed by 16 state governments. Well, it was originally filed by the Kogi state government. Now 15 other states have now asked the Supreme Court to be joined in that matter. And they're challenging the legality of the Economic and Financial Crimes Commission, EFCC, and they're contesting the constitutionality of the laws establishing the EFCC. The 7-man panel of the justices led by Justice Uwane Abahaji on Tuesday fixed October 22 for hearing in that matter, and they were joined by co-plaintiffs and leave granted for consolidation of the case in the suit originally filed by the Kogi state government. Don't forget, Kano, Lagos, Kogi state, some of these states have established their own anti-corruption agencies. Now, there is a federal anti-corruption agency like the EFCC. There's been some issues in the past, and there are judgments of court to the effect that some cases cannot be heard on corruption matter by the EFCC because there is the establishment of state-controlled or state-established corruption agencies. Now, this is 16 states, and we now hear that more states want to join them to challenge the constitutionality in the establishment of the EFCC. First and foremost, let's deal with this matter before coming to Senator Tony Nwoye. I'm being joined by one of the very most experienced lawyers in Nigeria, an elder statesman in every right, Senior Advocate of Nigeria, Chief Robert Clarke, who joins us live from Surulere in Lagos. Thank you so much, Chief Clarke, for joining us, and it's good to see you tonight on the program. Hello, Chief Clarke. I don't know if you can hear me.
I'm hearing you very well.
Fabulous. It's good to hear. I mean, I've heard that voice. It's been a while, and it's good to see you, sir. But let's begin the conversation.
Oh, well, you jettisoned me. You jettisoned me.
That's not possible. I don't just want to disturb you. I don't just want to disturb you. You're going to be 19 in a matter of months, isn't it? And, I mean, much respect to your knowledge, wisdom, and your experience.
Thank you very much.
Thank you so much.
It's always a pleasure.
Thank you so much. Always a pleasure having you join us. I want to get your view on this suit that has been brought before the Supreme Court. Of course, the Supreme Court has the court that can hear such a matter where there is a conflict or there is a dispute between state and federal agencies or federal government. Now, what is your view? The challenging the constitutionality of the establishment or the laws establishing the EFCC?
Well, I don't know the reasons why they are doing so. I do not have before me any documents showing the application that has been made. But from what you are trying to tell me, hello?
I'm here, sir. Please go ahead.
What you are trying to tell, From what you are trying to tell me, I can believe that they are not happy with what is going on. They want the matter to be reviewed constitutionally. And I believe that they have every right to do so. But until I see the papers or the application before the court, it will be difficult for me to make any statement on their reasons, because they are not making oral applications, but they are rather making specific written applications. So to that extent, in my opinion, or not, you permit me that area. What I'm trying to say is the legitimacy or no legitimacy of a law can be challenged by the governors. They have a legal right so to do, and I don't blame them. The facts upon which they are basing their application, I don't know. So I can just tell you that they have a legal right as governors to bring before the Supreme Court an action that challenges a law that is repugnant or is not informed with the Constitution. So that's how far I can say now. But if you enlighten me as to what facts they are bringing before the Supreme Court for their application, then I'll be in a better position to give a line of thought.
Yeah, Chief Clarke, part of the argument is the road involvement of states when making laws to establish these kind of agencies, and perhaps the procedure upon which such laws were made. And we do know that the history of the EFCC dates back to the Obasanjo administration. That was when the EFCC was established. But some of these states are contending that a law that was put in place to establish an institution that was in the first place without the consent of the state is something that they want to challenge in court. And we do know that when states come together, in the case of the VAT, they challenged the federal government, and we knew what came about. But in the process of lawmaking under our constitution and in constitutional law, what do you make of the stance of the state? Now there are 16 now. Kogi State for instituting that suit, and 15 other states joining in.
If you look at the antecedents of this law, the operation of this law, many of the very, very notorious, I will not use the word notorious derogatorily, has been involving governors, sitting governors that are out of office, and therefore they have every right to be jittery. If anybody wants to feel they are being jittery, to be jittery that this matter is merely created for the governor's purpose. But I do not see to that point. The creation of a law is the prerequisite of the legislatures. If there is any specific thing in that law that runs against the Constitution, then they should let us see it, and then definitely the court will set it aside. But if there is no law today that says the federal government cannot pass a law relating to criminal acts of governors during their period of executive work, then I doubt whether they are treading the correct ground. They cannot challenge the federal government for implementing an existing law. They cannot challenge the police or any other agency of governance that is executing the existence of an existing law. This law they are trying to challenge is a law that has been created and is part of our law as of today. So if they want to challenge it, if there are reasonable grounds to say the federal government has no power to be the executors of this law, then one looks at it at a different way. If they feel that even if the law is correct, it should be implemented both by the federal government and the state government. There are, I don't know what angles they are actually challenging.
Let me bring some context, a bit more of details on what the grounds. This was initially a Kogi State Attorney General's move on this matter. And the contention majorly was that they are seeking a declaration that the federal government, through the Nigerian Federal Intelligence Unit, the NFIU, lacked the power to issue any directive, guideline, advisory, or any instrument for the administration and management of funds belonging to the Kogi State government. They also sought the declaration that the EFCC, the NFIU, or any agency of the federal government cannot investigate requisition documents, invite and or arrest anyone with respect to offenses arising from or touching on the administration and management of funds belonging to the Kogi state government. Now, these are some of the premises in which they also went to court. They argue that bringing a convention into the Nigerian law, the provision of Section 12 must be complied with. According to them, the Constitution requires that the majority of the state assembly, houses of assembly, have to agree to bring the convention before passing the EFCC Act and others, which was allegedly never done. That was the main premise upon which the Kogi state government went to court.
Okay. I can now see the background why in particular the Kogi state government has gone to court, because they are in the soup as of now. But this is a point of law that is not meant for you and I to look at and be, talking about it on air as if it's a matter before the Supreme Court now. The Supreme Court is to look into it. My advice is that we can give opinions, but we ought to be very, very, very careful in giving an opinion when the matter is now before the Supreme Court. This is a sitting matter. The Supreme Court judges have to sit down together and deliberate about it. So we have to be very careful. But there are no facts that one can say is involved in this. But in doing all these things, we have to be careful, because most of the facts as of today they are going to use is already, what you and I know of the acts of sitting governors who have had the opportunity to sit on our Commonwealth and the way and manner they have done it. But let me assure you that the Supreme Court has the power, as of now, has the power to look into their complaint. If their complaint has a basis in law, definitely, I am quite sure that the panel of Supreme Court judges we have now are dedicated judges, and who will look at it with full dedication required of their professionalism.
Yeah, great. So now let me take you, Chief Clarke, to the matter involving the role and the execution of such roles by the judiciary. And we talk about the independence of the judiciary and the manner in which some judges or some courts administer their roles. There are a lot of people who find a problem in the manner in which courts of coordinate jurisdiction will deliver judgment in matter before them. People will raise the issue of coordination. People will raise the issue of bias. People will raise the issue of manipulation of the court processes. But as a very senior member of the bar, how do you think our country and our judicial system can overcome and solve this riddle that has sometimes brought the judiciary to disrepute?
It is very unfortunate, very, very, very unfortunate. I have discovered that the question of the interpretation of electoral matters, which takes over almost 100% of what you are referring to, are always on television, being a judgment by one court in Sokoto against an act in Shagamu, and all these things. My view now is that if we are not careful in Nigeria today, we will turn our courts into a kangaroo court, regardless of the status. Because if a court of coordinate jurisdiction give judgments at variance with each other, and superior courts give another judgment, and we make all these issues on television, whereby the ordinary man or woman does not even know what the courts are saying, we are treading on very dangerous ground. I have to be very careful. I was listening to one of your sister stations this morning. A lawyer was asked this type of question, and I was not happy even the way the lawyer was replying it. The lawyer was being asked whether the judgment in the Federal High Court is superior to a judgment in the State High Court, and why there should be conflict and all. It doesn't all go well for the judiciary in this country. We have to be very careful. And if any lawyer is being asked such a question, he should lay it down in a way and manner where lay persons like you and I can be able to learn from, for instance, if a state high court makes an order on a matter it has no jurisdiction, and the same matter is taken before a federal high court that has jurisdiction, definitely the judgment of the federal high court, who has jurisdiction, will be relied upon more than the state high court that has no jurisdiction. So we have to be careful that we, our lawyers ourselves, we should be able to enlighten viewers that what we are seeing now is not that Nigeria has kangaroo judges, but that the question of jurisdiction is at play. And we lawyers use the question of jurisdiction a lot to take advantage of our cases. So my view about this again is that there is no reason why today we should be bogged down by court judgments. We have created a situation in Nigeria now that if you are not careful, without sitting down, getting our senses correctly, and reenact and do or restructure whatever we want to do, we'll be treading on very, very dangerous grounds.
But Chief Clarke, how do we solve this problem? We have a new CJN in place. But of course, we do know that some of these issues are procedural. If you have any problem, if the NJC, for example, has any issue, I'm not sure the NJC can act unilaterally without any petition coming up. What do you think is the best ways in handling this? This has actually made a mess and a joke of our court system, where people think that they can jump from one court or the other in fishing and shopping for judgment, and when there are other courts that have given judgment in those kind of cases. I mean, it's terrible, and it mostly happens, like you said, electoral matter and political matters.
Well, let me give you a clear example, because I'm not going to shut up my mouth at my age and see many things happening in the judiciary myself that I'm not happy about. For instance, when the 1999 Constitution was being written by many of our colleagues who were good lawyers then, they never arrogated to the Supreme Court the power on electoral matters, except for the Supreme Court, except for the apex court, except to the presidency. All election matters emanate at the Court of Appeal level. But during the period of one of my very good friends at CG, it was decided by the Supreme Court judges themselves. Because when they were arguing this matter before, I told them that you have created a self-inflicted injury. Because today you are claiming you are the greatest working Supreme Court in Africa. You are the greatest Supreme Court judge or something in the bench at the Court of Appeal. And we would not have had all these problems while the Supreme Court today will be having on its list 500 matters, pre-election matters. Then they created it and they are suffering from it today. And they too should take it out, be able to allow Nigeria to breathe. I don't want to tell you about the instance that brought it up or the history that brought it up, but virtually every Nigerian knows about it. It's very unfortunate. Today, we find the Supreme Court hearing pre-election matters and using the same appeal on the pre-election matter to make pronouncement on election matter. Look at Zamfara case. Look at what the Supreme Court did to Zamfara case. It was a pre-election matter, and it got to the Supreme Court on a seat of 5 judges, not a constitutional court, but they sat there because they are kings of all kings and lords of all lords, as some of them say. And they decided to declare election petition matter on an appeal when they know they had no jurisdiction. Most of these problems is created by them too. And if we are not careful, Nigeria has to sit down and reform, especially on election matters. We have to have a new set of law that will guide us in election matters. If not, we're in trouble.
One matter, because you've seen Nigeria. Nigeria was, I mean, with some of you saw Nigeria. You are way older than the nation itself. Nigeria is just.
I was 12 years older than. I am 12 years older than the nation.
Absolutely.
I'm nearing my 90.
Yeah. So you are a senior brother to the nation, if you can put it that way. So
yes.
You've seen it all.
But I don't bet to. I agree with you.
You've seen it all. You've seen how everything has progressed. Yeah. So
and at my age now, I should be able to say it all.
Absolutely. Now, give us an understanding. You heard what Governor of Bayelsa says there about our federalism. What has become the Senate today debated the local government autonomy. Some states are still not complying. Some local government are still not in full picture of the judgment of the Supreme Court. Now, how do we fix this imbalance? The senator said there must be an urgent attention in the constitutional amendment to permanently fixing the role of the local government. But then, why is it difficult, Chief Clarke, to how we can make the very grassroots governance in Nigeria function well? How can we permanently fix the structure of this country? What structure or what style fits our nation? You've seen it all. What can you tell? We've seen parliamentary system of government.
Let me draw from my own experience.
Yes, sir.
Let me draw on my experience. Very, very good. The Chinese have surrounded us now with many things. But they have a proverb. The Chinese says, to build, you must destroy. That is the Chinese slogan, that to build, you must destroy. So I am appealing to the president today and those who are in authority, let us destroy all these laws we have now and come and restructure in the whole thing. Because you can't build something on nothing. We have nothing now. This local government judgment of the Supreme Court, I'm not happy the way it got to the Supreme Court. There are many ways, and that's why when the Supreme Court did that without consulting senior members of the bar who could have given them, I don't agree with the Supreme Court on that judgment. Not on the basis of what they have done. If they had wanted to change the whole concept of that law, we will have done so under another way of restructuring.
So how do we destroy and start all over again? Because there are a lot of people who say this restructuring. How do we do that? Do you see the present president being able to take that political move? Because it's going to be a very strong political move, and it's very tricky.
Look, when I was fortunate to be the former president's lawyer, the very gentleman I will always remember, I was his lawyer for 18 months. And when he was out of office, that is Jonathan, there was a time when he was the president, he wanted to restructure the law. But I told him that you cannot make a law when there is no legal tripod upon which you can place it upon. Because the same people who you want to restructure their laws are enjoying and benefiting from this law so much that to find a new member who has ever had more than one small car, wants to become a member of the House of Assembly, or wants to become, and within 2 or 3 years, you see the same man whom you knew was riding a tattered car. You will know the purposes of the office of that job is very good. And you're asking the man now to come and relinquish that job. They will not. None of these members today, from the president of the Senate to all these legislators, who will want to relinquish the journey their footsteps are on upon. Therefore, the president must do this. If I am somebody they can listen to, call a constitutional conference But before you call the Constitutional Conference, send a bill to the Parliament that, look, I want to restructure, but I want you to give me a bill that the way and manner I'm going to do it, this, and this, you will approve it and allow it to go for referendum after your approval. Without that, any restructuring being done outside any legal basis goes to nowhere. And Jonathan found himself in that position. Look how much was spent by him. Today, Adebanjo, my good brother, will be telling you, bring back this thing. On what basis? Whom are you going to give it to? If you bring it to their house today, they will throw it away. Because how can you say a man who before he became a member of the house was only earning about 10,000 a month, now finds that he's earning 5 million a month, and you say he should come and he won't do it. So let's be honest. The best way, ask Mr. President, send a bill to the House of to the Parliament that I want to do this. I want to call a conference. I want you to note that at the end of the day, whatever the conference decides upon, I will represent it to you in the House. Give it your approval and let me send it for referendum.
All right.
To give it the validity of law that is needed. Once we do that, we won't have all this problem.
All right.
We are human beings. We have made laws which we didn't know the effect. Now that we are seeing the effects and we are seeing the manipulation by politicians themselves after what they are enjoying as benefits of the office. So my advice is that we can still restructure.
All right.
But we must do it so that it will have a legal basis.
Chief
we
Robert
must have
Clarke.
a legal basis.
Yeah. I'm very sure that
Yes,
your experience and your legal advice tonight will get to the right quarters, and I hope that they use them. But thank you so much. It's always good to learn from your wealth of wisdom and experience. Thank you so much indeed, Chief Robert Clarke, Senior Advocate of Nigeria, by far one of the most experienced lawyers you can find around. Thank you so much indeed.
God bless you for me always.
Thank you so much, Clarke. It's always a pleasure, sir.